En primer lugar, querría cederle la palabra a Aniko Gyenge. Aniko es actualmente la jefa de la Unidad de Protección de Consumo, Derechos de Autor y Propiedad Industrial del Ministerio de Justicia de Hungría. Asimismo, ha desempeñado una amplia labor en el campo de la investigación y cuenta con distintas publicaciones en materia de derechos de autor. Por último, se ha de destacar que recientemente ha participado activamente en los trabajos de elaboración de la nueva ley húngara sobre obras huérfanas, con lo cual nos podrá ilustrar sobre dicho trabajo. Por favor, Aniko, tienes la palabra.
Thank you, Raul. Good morning, everybody. First of all, I would like to say thank you to the organizers for inviting a Hungarian speaker to this very timely conference. As you might have realized, there was a little change in the program. Unfortunately, my State Secretary, Ms. Judith Fazekas, cannot attend your conference because she must take part in the CUTS meeting in Brussels. This is why I have to apologize, first of all, but I do hope that I can serve you as a substitute speaker. Sorry. We were asked to speak about the new Hungarian rules on orphan works, especially about the policy questions, such as the considerations of choosing the model of special licensing. In the second part of my presentation, I will introduce you to the elements of the existing rules, and as a final step, I will mention some directions in which the actual Hungarian law could be developed on the basis of the future EU law. First of all, I have to emphasize that the new legislation, about which I will speak a bit later, is only one tool of a more complex system of opportunities to legally use works which are protected, but we don't know their right holder or we are not able to find them. These opportunities in the Hungarian law are the following. First of all, I have to mention the extended collective licensing system. According to the Copyright Act, the collecting societies registered at the Ministry of Culture and Education authorize the use for the users, and on the basis of this license, the user shall be entitled to the same use of the word repertoire. But I have to mention that in the Hungarian system of collective management, the collecting society is registered for concrete rights of concrete groups of right holders. The power of the collecting society covers exclusively the group of the right holders and the type of their rights in regard where and whom it is registered. The second possibility is the exceptions and limitations system. According to the Copyright Act, uses falling within the scope of the free use, as the Hungarian Copyright Act names it, shall not be subject to the payment of any consideration and to any permission of the author. We have a very, very long list of exceptions and limitations for private uses, education, archiving, scientific research, and so on. They cover practically all types of the rights, but they are strictly bound to the specialized and reasoned aim of the use. And finally, I have mentioned the regulation on anonymous and pseudonymous works. These state that if a work was published anonymously or under a pseudonym, the author's rights shall be exercised until the author becomes known by the person who first published the work. As a consequence of this complex system, there are many rights covered by collective management which cannot be orphaned practically. There are many types of uses covered by exceptions and limitations, which don't require a license. And there are a third group of works of which author isn't identifiable for everybody, but it can be licensed by the publisher. Keeping this in our mind, when we prepared the special legislative solution for the problem of orphan works, practically we had only to complete this system in regard of the uses which don't fall within collective management, exceptions or limitations, or under the rule of anonymous and pseudonymous works. So, that was the legislative situation in Hungary before 2009. The new Hungarian legislation followed the call of the European Commission I-2010 initiative, which proposed that the member states take concrete steps to solve the problem of licensing such rights, which cannot be licensed in other traditional ways. The Hungarian law refers directly to the Commission recommendation on the digitization and online accessibility of cultural material and digital preservation. Of course, we know that this isn't a binding law, but in Hungary there was another and perhaps more important argument supporting the introduction of a solution, because it was already an acute and very practical problem which needed a prompt response. And that was the legal situation of our national film heritage. Most of the rights of the older Hungarian films are owned by the state, thanks to their nationalization during the communist era. The nationalization covered all the rights which were guaranteed by the 1969 Copyright Act. Nevertheless, the digital rights, and especially the right to make the work available to the public online, remained behind with the original right holders, who are mostly unknown, or we don't know where they can be found. This was due to the old principle of the Hungarian law, namely that no license can be validly granted for a means of use that's unknown at the time a contract is concluded. This principle was acknowledged by the court as regarding the nationalization also. On this legal basis, the older Hungarian films couldn't be made available to the public online, and they were dying in the archives. The problem couldn't be solved by collective management because the right holders of the films who are known would like to license the making their films available to the public online individually. We couldn't create an exception either because it would have been an obvious infringement of the EU law. Of course, we had also got some information from our libraries that they couldn't digitize their collections and they couldn't make their collections publicly online. But we didn't get any exact data about how many items of the collections can be qualified as orphans. Nevertheless, it was an indication that we have to find a general solution for the orphan works, and we have to take into consideration all of the similar problems. Of course, before amending the Copyright Act, the Ministry of Justice and Law Enforcement analyzed the possible regulatory models which seemed to be applicable for solving the situation. For example, the Nordic member states of the EU use this blanket license system for licensing orphan rights, but in the frame of the Hungarian copyright law, only the collecting societies can use blanket licenses, and even then, exclusively in relation to the rights which are managed by them on the basis of their registration at the Ministry of Culture. So their competence is not a general one, and it doesn't apply to all orphan rights. The potentially orphan rights are so diverse, and the identifiable right holders practically are not interested in collective management, that the collective management organization and the system of blanket licenses didn't seem to be an appropriate solution. The government examined the US bills on orphan rights also. According to the US model, the remedies for infringement shall be limited if the user proves by evidence that before the infringement began, he or she performed and documented a qualifying search in good faith for the owner of the copyright and was unable to locate the owner of the copyright. We think that it's an excellent solution, and I think it's the cheapest one also, but our cultural institutions, especially the different state-owned collections, indicated during the consultations that they can't support the introduction of such a regime because of a practical problem, because the costs of it are not predictable, and that's why they can hardly build the risk of infringement into their budget. Nevertheless, one element of the US proposal should be adopted. This is the principle of diligent research, which was also emphasized by the Commission, and which can be found in the Canadian orphan works legislation too, which, as we will see, became our primary model. After taking into consideration these models and the practical arguments, the government chose the Canadian model, the introduction of a special licensing system. The amending act of the Copyright Act was adopted in December 2008 and entered into force on the 1st of February 2009. The system for licensing orphan rights has been completed by the adoption of a government decree. It entered into force on the 16th of May 2009. This means that the functioning Hungarian system is a newborn baby. According to the law, the Hungarian Patent Office grants a license for a proportionate royalty for the applicant who carried out a due diligence research, depending on the type of the work and the use applied, but didn't succeed to find the right holder. A diligent search for the right holder is required as a precondition for lawfully using an orphan work. Sector-specific criteria are to be applied when examining whether a diligent research has been performed. The fact that a diligent search has been performed needs to be documented. The mentioned government decree establishes a non-exhaustive list of measures that may be taken to perform a diligent search. The examples given don't constitute a minimum number of search steps either. A prospective user can perform a diligent search without taking all the measures listed, but on the other hand, even taking all the measures on the list may not amount to a truly diligent search. This has to be determined with due regard to the individual circumstances of each case. The government decree makes it clear that its provisions are to be applied mutatis mutandis to licensing the use of performances. Therefore, other related rights, such as the rights of phonogram producers, film producers, and broadcasting organizations are not covered. Significantly, these rights are owned by legal entities, and it might perhaps be said that the successor of a legal entity is easier to identify. The license is valid for a maximum of 5 years within the territory of the Hungarian Republic. It's not exclusive, it cannot be transmitted, it doesn't cover the right to give further licenses, and it doesn't allow the adaptation of the work. If the use isn't designed to earn or increase income, the compensation shall be paid after the author or his place of residence become known. If the use is designed to earn or increase income, even in an indirect manner, the compensation shall be deposited in advance with the Hungarian Patent Office. The new Hungarian legislation in such a way offers a preferential treatment for non-for-profit uses. If the right holder reappears when the license is still in force, The Patent Office revokes the license without a retroactive force, but leaving the possibility for the licensee to continue the use for the time remaining from the license for a maximum of 1 more year. The right owner can demand the royalty a maximum of 5 years after the revocation of the license or the expiration thereof. After this period of time, the Patent Office transfers the deposit to the National Cultural Fund. The National Cultural Fund shall use the money for making cultural goods accessible. If the sum of the royalty is contested by the right owner, the rules of the Copyright Tribunal proceedings are to be applied. The Hungarian legislation also provides for a register of orphan works. It's to be kept by the Patent Office, but only in respect of those orphan works for the use of which it has granted a license. It's a publicly available administrative register which is accessible electronically. As a final remark, I have to emphasize that a new legal regime and its first working year shouldn't be adjudicated upon. We cannot yet judge its effectiveness practically. Of course, we don't know to what extent the Hungarian scheme would fit in with a Europe-wide solution to the issue of orphan works, and in particular, whether and under what conditions it would ensure the mutual recognition of different arrangements in various EU member states. But we are open to methods of improving our new system, and it's our intent to export the positive elements of the system to the European level. I hope that we will have the possibility to do this during the future Hungarian presidency, where a major copyright priority is the promotion of the EU-wide solution to the problem of orphan works. I don't think that we could describe ourselves as having finished our work at the end of the day, but I'm sure that we have taken the most important step as the first step, and I think that the Hungarian government is committed to going forward on this path. Thank you very much.